If you want to come forward, we'll call our last case of the day, which is 128-299, State of Kansas versus Sawyer. If you'll state your appearances.
Meredith Hogan, appearing on behalf of the appellant, Tyler Sawyer.
May it please the court, Assistant District Attorney Matt Maloney for the state.
And Ms. Hogan, would you like to reserve any time for rebuttal?
Yes, Your
How much?
Honor. 3 minutes.
Okay, 2 and 3. And we have a Hogan case on our docket, so if we get those two confused, forgive us, please. Hopefully no relation.
Probably not. Hopefully.
But you may proceed.
May it please the court. Your Honors, this case is about a man who was battling addiction, and he returned to his childhood home. Despite a lot of issues that he and his mother had had over the years, including his addiction, she had always allowed him to return to his childhood home and had given him offers of help over the years. His defense in this case was based on a simple truth, that he had no memory of being served with a temporary protection from abuse order, so that he didn't understand or know that his mother didn't allow him to be in her house any longer, that she was withdrawing the authority to enter her home or to use her items.
Help me remember, how much longer was it that he was in her home after he actually had it in his backpack?
It was a little bit unclear from the trial testimony from what I remember, but I believe he was living with her in about September of that same year, and then there was an incident on like September 25th, and then she filed for the order of protection on like the 29th of that year, and then this occurred on October 7th. So it had been a very brief period of time.
A week or a few days to a week?
Yeah,
Okay.
a very short period of time, Your Honor. And during that time, after she had filed for the order of protection, she had done things that didn't give Tyler any indication that she had withdrawn authority to enter her home. She had still brought him clothes to his girlfriend's house. She had sent him and his girlfriend, money through some sort of a Cash App means, so that they could purchase groceries. Essentially, he had no indication from her actions that she had withdrawn authority to enter her home, or that she was withdrawing, like, helping him in any way, so that he didn't know that that authority had been withdrawn.
But acts of supporting someone when they're not in your home can't really be equated to inviting someone into their home or saying that she wanted him in her home, correct?
I think that is fair, but up until this time, she had allowed him to come over and to, eat food. She provided for him because he was her child. And so I think he just didn't understand that he was no longer allowed to do that.
And when were those acts you've just mentioned of acts of kindness? Were they after she filed the PFA?
Correct. Yes, that is what the trial transcript indicated, but like the particular dates were unclear, but it was a very brief period of time between those two, the act and the incident.
You're saying taking him clothes meant that she's still giving permission to come into her house?
I'm meaning that it wasn't an indicator that she didn't want him around, because she was going to the house where he was staying temporarily with his girlfriend on occasion, and so she was getting close to him even though she had filed for this temporary PFA, which indicates, or like a temporary PFA is to prevent him from coming to her, coming around her, coming to her home, anything of that nature. So she was giving him no indications from her actions to show that she didn't want him around anymore.
Except for the PFA.
Yes, but he didn't know about the PFA until...
Well, that's his allegation, right?
Correct, yeah, and that's what his entire trial defense was based on, was his lack of a memory at all of having been served with this. And so he went all the way through trial. His trial counsel presented a defense based on his lack of memory, arguing successfully, I think, or impeaching Officer Johnson's testimony that he had served Tyler with this PFA, or the temporary PFA. And so it wasn't until that very last morning of trial that they found out, sure, he had been given this temporary PFA, but it was while he was incoherent and incapacitated. There was no ability for him to understand what a temporary PFA meant or like what that officer was saying to him so that he would understand that that authority had been withdrawn, that he was not supposed to go near his mother anymore.
He didn't get it, he didn't, yeah,
Sorry.
didn't register with him at the moment he received the PFA.
Correct. Correct.
But was it not found in his possessions when he left the jail?
Sure, but there is a difference between physically possessing an item and knowing that it's there. If he was leaving the court or the jail and he was looking through the items and said, oh, what's this? And she said, that's a temporary PFA. It says you're not supposed to do X, Y, Z. That would give him that knowledge.
Well, he could read, correct?
He could, but he was just released from jail early in the morning with no shoes, maybe no
He had
food.
several days after that, you know,
So this
before
was
this
the
event at
next
his
morning.
mother's. I'm sorry, that was the morning that he went to his mother's or not?
So I'm sorry, I didn't mean to interrupt you.
That's fine.
So he was served with that temporary order on October 7th, which was a Saturday. And then he was in jail, so he didn't have access to that information at all. And then he was released at like sometime later, walked 10 miles, and arrived at his mom's house on the 8th, which is a Sunday, at like 6 a.m. or 6:30 a.m., something like that.
Okay.
So it was a very brief period of time, most of which he was incarcerated. And so in that video footage, it shows that Tyler was incoherent and incapacitated, such that he could not accept service of process for that PFA because he couldn't understand like what it meant. He wasn't
Well,
being
do we
given.
have to understand when somebody comes and serves us with process? Do we have to understand it, or is the obligation of the deputy or whoever served in this case simply to make sure that it's personally served?
So in this case,
Because I may not understand a lot of documents somebody gives me.
I doubt that. But so in this case, the officer said that he specifically went through the document and he would explain to a person who was accepting process.
That sounds above and beyond. I mean, and tell me if I'm wrong, but it seems to me that there's probably a lot of deputies out there that says, you've been served, have a nice day, and they leave, and don't take the time to explain what it is they just served them with. Sometimes they may not even really know what they're serving with. I assume
the
a
deputy.
PFA they would know. But do they have an obligation to explain?
The statute doesn't state that there's an obligation, but this officer, because it is his standard practice, imposed on himself, I think, a duty to explain it and did as he
So you assumed a
said that he
duty.
did. Correct. And that the purpose of that service of process is to make sure that they understand that they cannot, that there is a viable court order against them preventing their access to this person or preventing them from doing certain things.
I thought that was the purpose of the writing.
Well, yeah, but the service of process with those
Not the
indicators.
service of the personal process to make sure they got the writing.
It's to give them notice of the allegations against them.
So like if we get sued, they don't sit there and read the petition to us. They serve it to us. It shows that you've got it, and then it's your obligation to read it.
Correct, but I think in this type of case where there are allegations being made against him about conduct that prevents his access to a person that he regularly consorts with, and then he was immediately put into jail where he didn't have access to that document, and while he was being given that document, he wasn't aware of what was happening around him. I think there was an obligation to give it to him at a point in time where he knew that he was being given that document so that he would know to read it later.
Well, let's say it was appropriately served on him, but he didn't know. It still seems like you have, at least your argument here, that there's a Brady violation, that there was some type of body cam footage that was not.
They shouldn't got to the
Brady.
Brady yet.
Yeah.
I'm sorry, I couldn't hear that.
I
last
said you
part.
haven't got to the Brady yet.
We're trying to encourage you to get to the Brady.
Oh, my
violation
apologies.
allegation.
Yes, so the whole issue in this case, or the primary issue in this case, is the fact that the state failed to provide exculpatory evidence in this footage showing that Tyler was incapacitated and incoherent when he was given this PFA document, so that he didn't know that it existed. He didn't know what these allegations were. He didn't know what his obligations were under that temporary PFA, stating that he wasn't allowed to go to his mom's house, to be near her, to contact her. He had no idea because he was incapacitated when he was given that information. And then it also meant that he didn't know that he possessed it, so that he needed to review it on his 10-mile walk in the middle of the night.
And
so
that was rightly or wrongly, that was the basis of his defense. is that I was incoherent when evidently I got this piece of paper, I don't know when, don't know how, and had they given me this, it would have supported my defense.
So the original basis for his defense, because he didn't remember being served with this at all, and Officer Johnson's, like the service document itself, indicated that Officer Johnson was not even the person who gave it to him, and it was dated on the 10th of October, which was after the incident that occurred here. And so that would have indicated that he wasn't served with that temporary PFA until after the allegations showing that he was unauthorized to enter his mom's house. And so his defense attorney had based her entire argument on he was never actually served. He didn't know that this happened. It wasn't served until the 10th. Officer Johnson, maybe he's remembering something else, I'm not sure. But that his testimony was incorrect, his notes were incorrect.
So-
Oh,
I'm sorry, I didn't mean to interrupt.
sorry, you're okay.
I have a problem with the Brady claim when it's not in the record. So how can we evaluate your allegation when it's not in the record? The kid body cam,
footage, like-
the body cam is not in
I
there to
understand.
support the Brady claim.
I figured that would be a question that would come up today. And so I think the court should take the stance that was taken in Newsom, which was done by a different panel of this court. And in Newsom, the trial court didn't review the body cam footage at all, which is the same circumstance here. And so in Newsom, the appellate court found that the failure of the trial court to review that footage before ruling on the Brady issue was ultimately an abuse of discretion de facto, because there were no factual findings, or there was no substantial competent evidence to base fact findings on to make that Brady determination. And so that court, even though the footage or the text messages and things were in the record on appeal for that case, the fact that the trial court hadn't reviewed it at all was a determinative factor. And here, the trial court was required to make findings of fact to support its Brady determination. It didn't review any of the footage to have substantial competent evidence to make findings of fact, and that is de facto an abuse of discretion that requires a new trial in this case. Additionally, I think that this court is in a very different posture from the district court in terms of its obligations, because this court has the obligation to defer to the district court's fact findings, but if there are no fact findings to defer to, that's obviously a problem. If the district court had reviewed the footage and made its fact findings, this court would give deference to those and wouldn't, I think, arguably wouldn't even have to review the footage itself. But so the fact that the trial court didn't review this footage at all means that it's unnecessary for this court to do so, because it was a de facto abuse of discretion.
And that's by another panel of our court.
Correct, Newsom. It came out in late last year, so the citation on that is 65 Can App 2D at 329. And I can't remember, I think Judge Hill was on that panel, and some other judges, but I don't believe it was any of the judges on this panel.
If not, we don't remember. So I want to make something that, it's just me that probably doesn't understand this. So Sawyer requests a mistrial, right? And then the judge granted a request to exclude the video. Who requested to exclude the video at that point?
It was an alternative request of defense counsel, so the
Because
state.
why would defense, it seems like defense counsel would want that to come in if the defense is, I'm incoherent, I'm calling my mom by the wrong name, et cetera.
So the problem is that she had, up until this point, had a defense of he was never served. So to change on the very last witness to a defense of he was served but he was incapacitated, that's really harmful to the entire defense so far. But that request to exclude the evidence, because it was looking like the trial court, or it had already denied the mistrial, as an alternative, it was just an alternative kind of temporary remedy. It was not sufficient because, again, there were a lot of other problems in this case that resulted in an unfair trial. But I think ultimately the fact that it was excluded is, oh, sorry.
Well, I'm thinking, what's the duty of the defense attorney to send a request for production for discovery of all the items that the state has?
None. Because this was exculpatory information or impeachment evidence,
Well,
the trial, or
we
this.
don't know that.
Well, there's Supreme Court precedent saying that the state has an affirmative obligation to provide any and all Brady-related material affirmatively. It doesn't have to be requested. It helps, but it doesn't have to be requested in order to create
I
that
understand the
obligation.
affirmative duty,
Okay.
but isn't there a duty on the defense counsel to request documents too?
I think it would dilute the state's obligation. But also there was a request for production of evidence in this case. It was very early on before the counsel that was ultimately trial counsel, because there was like a switch from original counsel to the trial counsel. But there was a request for production of evidence that was given.
Well, you're past your 12 minutes initially, so if you
Oh,
want to save some time for
apologies.
rebuttal, you might want to go ahead and wrap up this portion.
Yes, Your Honor. Ultimately, this case was the result of a Brady error because the footage was exculpatory. It's a very low standard. The state withheld that evidence, and that delay in holding that evidence resulted in prejudice and an inability to use it effectively at trial. It was material evidence and would have resulted in a reasonable probability of a different outcome. And I will reserve the rest of my time for rebuttal.
Thank you. Mr. Maloney.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I think there are numerous points that I want to make in response to counsel's argument. I hope that I address them all in the brief. But I think first we do have to back up here. And with respect to the Brady violation, first of all, case law is clear that there's a distinction between delayed disclosure and actual evidence that is not disclosed at any point during trial. This is a situation that falls in the first category. This was discussed and came to light on the first day of trial, and then the prosecution did find the videos and showed.
Did you say the first day of trial or the last day of trial? Because I thought the counsel said the last day.
It was the first day of trial, Your Honor, when this issue came up during the cross-examination of Officer Johnson. That defense counsel cross-examined him about whether he was wearing a body camera, and he said yes, and then went on from there. And so then it was before his testimony ended that the defense moved for a mistrial, and then over the course of that evening is when the prosecution found those videos. The next morning is when the issue was further discussed. So this was.
So in the meantime, did the defense counsel and the defendant have the opportunity to review the video and to have a little time to consider how to react, or what happened once the video got disclosed?
Right. So the following morning, the prosecutor informed the court that he had shown the video to counsel that morning, and then explained why he had not previously downloaded it. And then defense counsel responded that she had seen a portion of the video, the portion that purported to show Officer Johnson reading the PFA to the defendant. Counsel did note that the full video appeared to be much longer, and she renewed her mistrial request. And then that was when the court essentially said, look, based on what you've told me, this not only would not be exculpatory, but it would actually completely shoot a hole in your theory of defense, which has been that he did not receive the PFA. So yeah, so it was basically the first day of trial is when the issue first came to light, and then the next morning was when the prosecutor showed what I guess would consider the meaningful portion of him showing the PFA to the defendant.
So your position is that this was not exculpatory evidence that would have been required to be unilaterally disclosed, that this would have just fell as a response to any discovery request that was made?
Yeah, I think it certainly falls in that category where, because it was turned over late. But yes, I definitely don't think, and certainly the district court was adamant in saying this was not exculpatory evidence, that this blows your theory of defense completely out, because it does show that the defendant did receive the PFA. Now, counsel has pointed out, well, here's how I would have dealt with that below, and essentially said, now I would have tried to use that to justify an instruction on voluntary intoxication or on mental disease or defect. I think that's kind of shifted throughout time. I think below, my recollection was this seemed to be more of a mental disease or defect argument, and now on appeal it's turned more into the voluntary intoxication. But the fact that the defense could have come up with a strategy to try to combat evidence that was harmful to its case does not make it exculpatory evidence. The fact of the matter is, it shows the defendant being served with this PFA. So I definitely don't think it's exculpatory. It was turned over. And I absolutely maintain, as I did in the brief, that the defense's failure to proffer the video itself and to have that in the record on appeal, I simply don't know how we can get past that. He has to show that this was, for a Brady claim to succeed, obviously you have to show that it was exculpatory. That's the heart of what a Brady violation is. And I recognize that defense counsel did make a proffer below as far as the contents of the video. There was this brief description. And I'm not suggesting that counsel in any case is not allowed to make a proffer. And I'm not even suggesting that what counsel proffered was not factually accurate. But the fact remains, their whole argument on appeal is predicated on saying that this video was so important, and not only was it important, but it was exculpatory, that it would have affected the outcome of the case, because that's what they have to show, because it was delayed disclosure. It was not something that was never given to the defense. They did have an opportunity to use this. So they
Was there
have
any request for a continuance, or, sometimes if evidence is belatedly disclosed, there'll be a request for a continuance for half a day or whatever?
Absolutely. That's an approach that they could have taken. They could have chosen to, if they wanted to, they absolutely could have put that into evidence themselves and said, okay, now that we have this, we are going to use it in the way that counsel proffered they would. And I know counsel said, well, that would have been inconsistent with the defense that they had been running up to that point. But again, this was early in trial. It was during the state's case in chief. The defense had yet to put on any witnesses or evidence of their own. And we all know that parties are allowed to run inconsistent defenses. So to the extent that they wanted to, they absolutely, if they felt that this video was so important, so helpful to their client, they absolutely would have had the option, as Your Honor pointed out, to request a continuance and say that they needed a little bit more time to figure out how they wanted to handle it, or they could have simply chosen to admit it. But instead, they did neither. And again, I'm not...
Well, they actually asked that it be excluded, isn't that correct?
They did, as the alternate, exactly right. And that's,
Which was kind of a point of punishment against the state.
Yes, and I think a very reasonable alternative option that the court chose to follow there is to say, I'm not going to prevent the state from putting on witness testimony from Officer Johnson to say that he did serve this, but I'm also not going to let them play the video. And that gave the defense the opportunity to still continue to argue essentially that, well, we don't really know that he was served with this or that he was informed about it. So I think it was a fair solution by the court. But again, I simply can't understand how the defense is asking this court to find that this video was so important and that it was exculpatory without showing the video. Again, I'm not suggesting that trial counsel below was making anything up in describing it, but no person, no matter how articulate they are, is going to be able to describe a video where the key issue essentially is the defendant's demeanor, apparently. Whether he was acting so incoherent and it would show that he surely couldn't have been able to understand what he was being served with. Nobody can describe that as well as what you would be able to simply see if you watch the video. we've all seen people in various states of whether it's intoxication or if they're arguing drugs in this situation. There's not a one-size-fits-all standard here. There are people who are maybe a little bit intoxicated, but clearly still have a basic understanding of their circumstances and are able to understand and process the world around them, and something as simple as, this is a PFA, you're not allowed to go to your mother's home or to be around her. That's on one end of the spectrum, and then of course at the other end there are people who clearly would be much more incapacitated. And again, my argument is that there's no way that somebody simply summarizing a video showing a person's demeanor and mental state would be nearly the same as actually having the video. I do want to note, just in response to some other comments that counsel made at the outset of her argument, we also have in the record testimony and evidence from the victim saying that she had told her son on October 7th, when he showed up at the house, that he was not allowed to be there and that she had taken this gotten this PFA. So while there was some testimony about things that she had done to try and help the defendant, sending clothing and perhaps speaking on the phone with the defendant, there's uncontroverted evidence that she had made clear to him the day before, at a minimum, the day before, she had told him personally, you can't be here. You can't be at this house. You can't be around me. So to the extent the argument is that this whole case hinges on the defendant not knowing, that's additional testimony in addition to what we had from Officer Johnson. But again, just to summarize, I think that the absence of the video, it is always the appellant's burden to designate a record showing reversible error. We know that this video existed. We know that the defense had access to it as of the second day of trial. Clearly, that would have been an opportunity, even if the defense for some reason didn't think to request a continuance at that point. They clearly could have said, Judge, we haven't yet seen the whole video, but we would like some time to do that, and or we simply would like to proffer and put the whole video in the record at a minimum for purposes of the appellate record so that everybody can know exactly what this video shows. But instead, we have a panel of 3 judges and 2 attorneys up here who are just having to talk about a brief proffer, trying to figure out, well, what does it actually show? My position is that that's not sufficient and that alone should be enough to defeat the defense's argument. But even if you don't want to go that far, I think that what we do have in the record from the district court level shows that this was not exculpatory. It was damaging evidence. There's a reason why that was the backup request from the defense, would be, if you're not going to grant a mistrial, we would ask that you not admit the video in the record. You don't.
Earlier, counsel mentioned the decision by another panel of this court in Newsom, and she says it was an abuse of discretion for the court not to review the video before it determined whether a Brady violation occurred. Is that correct?
I'm not as familiar with, look, I was reading through the defense's brief as she was arguing, and her citation to Newsom was very brief and certainly didn't, was not that in depth. So I'm not as familiar as I should be, and I apologize with the facts.
Well, no. So my question is, though, if defense counsel on the second day of trial, after they had reviewed the video, asked the court not to allow it to be shown to the jury, did that eliminate the need for the court to review it if the defendant didn't want the jury to see it anyway?
I would argue so, and that certainly is.
I'm trying to figure out this is kind of a fine point to me.
Right, no, but it's important, and I think that does crucially distinguish the case. To the extent that in Newsom, the defense was asking the court to review whatever video evidence there was, and the court simply refused to do so, then that's a lot different than a situation where here, I don't recall that the defense, first of all, ever specifically asked the judge to take the time to review the video himself before ruling on it. And then second of all, yes, when the defense then turns around and says, okay, my preference here would be a mistrial, but if you're not willing to go that far for whatever reason, then alternatively, we would simply ask that you not allow the video in. Then I think, yes, once the court has been faced with that alternative request and has decided, yeah, I'm not going to allow the state to admit the video, basically as punishment for not having turned it over before trial, then I think that does probably eliminate the need for the district court to review the evidence at that point. But I don't think it absolves the defense of the responsibility to at least put the video in the appellate record if they're wanting to now argue that this was such a critical piece of evidence in their favor. But again, the very fact that their backup request was exclude the video, I think says all we need to know about the contents and whether it was exculpatory. I'm not a trial attorney, but I can't imagine if I was holding on to a piece of evidence that I felt was, aha, this favors my client, that I would then say, Judge, this is such good evidence that I don't want you to show it to the jury. I don't want anybody to see this, so please exclude it. So I think that does speak volumes about what this video actually showed and whether it was favorable to the state or whether it was exculpatory, as the defendant would have this court believe. I think I've touched on all of the points that I plan to today. Again, I would just argue that in this decision, the district court, I think, came to a reasonable and fair compromise. This wasn't something that was disclosed after trial. It was presented during trial. It gave, I cited in the brief the Breitenbach case, I believe, where on the second day of trial, the defense was given a fingerprint report and on appeal tried to argue that that was a problem and that that was a Brady violation. And I think the Supreme Court essentially said here that it wasn't that it wasn't disclosed, it was disclosed. The defense had an opportunity, and in that case they did say specifically one thing they could have done was ask for additional time, or they could have used it themselves. And I think that's very much the situation that we're in this case as well. I'm probably at my time, so I would just sum up by asking this court to find that the district court did not err in its handling of the matter and ask this court to affirm the district court. Thank you.
Ms. Hogan?
If I may proceed.
Yes, you may proceed.
Your Honors, I think that the fact that she asked as an alternative that this information, this footage be excluded is due to the fact that a trial counsel at the penultimate moment, where only one single witness is left to testify, that witness was not present when he was served allegedly with this document. She had to weigh the loss of credibility that she would experience as trial counsel and our client facing incarceration for a long period of time. She had to weigh the effect of that loss of credibility from immediately changing and suddenly changing her entire defense strategy. She had to weigh that loss against what the effect would possibly be otherwise. And so because she had been pursuing a defense strategy that was based on the lack of service by itself, excluding that, if the trial court wasn't going to grant a mistrial so that she could pursue that evidence for a voluntary intoxication defense, this was the next best alternative rather than losing a substantial amount of credibility as trial counsel and for the defendant.
So it's trial strategy because it was this video, we don't know exactly what it shows, but it sounds like it could have been a two-edged sword because on the one hand, it's going to show he got served. On the other hand, may or may not be exculpatory, but it could have showed that he was not of sound mind when he received it.
I think that actually also goes to another error or fact of law that occurred here. It seems that the trial court was interpreting it as entirely inculpatory because he was given this document based on what the strategy had been thus far. And the strategy thus far had been that he had never received that document, he was not served with that document. So the trial court was reviewing this footage from that lens of what was your defense so far and not looking at it of what could it have been used for had it been provided before trial, because a Brady violation is really a violation of your pretrial rights. so that it can be used effectively at trial. So rather than looking at it from that lens of how could this have been used had it been provided with sufficient time to be effectively used, it looked at it from, we've gone through 4 witnesses that the state had provided with one defense strategy and suddenly changing it. So I think that just compounds the issue. And then the fact that the trial court allowed a last witness to testify to kind of build up the state's case that he had been served. That person was never there when he was served. She couldn't be cross-examined about this footage at all. And that means that it could not have been
Are
effectively
you
used.
talking about the late endorsement of a witness?
Yeah, I think that it kind of compounds the Brady issue because it was used to prop up Officer Johnson's testimony when he was successfully impeached on the service document. The state wanted to introduce that last witness to prop up his testimony, but because she wasn't there when this footage was being filmed, she couldn't be cross-examined about that footage at all. So it was literally not able to be effectively used at trial.
What is your response to counsel's argument that your failure to proffer and produce as evidence the video defeats your Brady claim?
I think it still goes back to Newsom, that we start from what did the trial court do before we even get to what was in the appellate record. And the first question that we ask is, what did the trial court review? It did not review the footage, and it had an obligation to. And under Newsom, which is a published opinion of this Court of Appeals, the district court was required to make findings of fact based on that footage, and its failure to do so is an abuse of discretion, which requires a new trial.
So, but if the defendant it's requested the court not to admit it to the jury, why would the court need to see it?
Because he had already denied the mistrial request. And so this was a secondary, like a backup plan, because all of the judges, all of the trial court's statements that thus far had been indicating this is gonna get denied. He's not gonna get a new trial so that this information can be used effectively. So what is the least harmful alternative? I guess it is to exclude it because I don't wanna lose credibility in front of this jury. My client's interests are at stake here. And so I think that was just a backup plan. I think the fact that this mistrial was denied without reviewing that footage is an abuse of discretion by itself. If this court has no further questions, I would rest our case and request that this panel find a Brady violation occurred and that Mr. Sawyer deserves the right to a fair trial and a new trial. Thank you.
Well, thank you both, and we will take this under advisement and hopefully get an opinion out to you pretty soon.